Colleagues, I'm Crispin. I'm the Member of Parliament for Reigate in the county of Surrey, and welcome on my behalf to so many great Commonwealth colleagues here in Westminster today, and it's my privilege to be able to chair this session on the nexus between culture and rights. And I will only speak very briefly before I introduce three practitioners in this area, but I make some small claim to that role myself. And I want to simply illustrate the challenge there is in this area by two of the strands of the work that I do, which are two causes I've been able to take up, having been invited to leave Mr. Cameron's government about 2 years ago, and given me the freedom as a having now been a Member of Parliament here for nearly 18 years, to use the mandate I enjoy then to follow up issues which might not be called majority sports in other terms. One of those pieces of work has been trying to reach out and understand political Islam, and I've been engaged for about 10 years working through an organisation principally called Forward Thinking, principally to get a better understanding, particularly of the Muslim Brotherhood and its politics and its approach. And the other strand of my work has been as an individual. I came out as gay rather recently in 2010. I was a serving minister at the time, so it did get some attention in the newspapers, at least for 24 hours. And after I stopped being a minister, I have been engaged in the work of the Kaleidoscope Trust, which is a UK NGO which seeks to help LGBT activists in parts of the world particularly where same-sex relations remain criminalized. Now that's, and one of the reasons I do that work is, it's my payback to those British people who fought that cause here 30, 40, 50 years ago, and were very much braver than I in taking a position when it was not only illegal, but also, but even when it ceased to be illegal, deeply unfashionable, and certainly for someone like me who wanted to be a soldier, incompatible with being in the army at the time I joined it. And so I'm feeling an obligation then to give some assistance to LGBT activists through the work of the Kaleidoscope Trust, and obviously that issue is part of the discussion we're having today. But the linkage between those two pieces of work is, one would have thought that the rights for LGBT people and political Islam are wholly incompatible. And in my discussion with political Islamists, my objective in the discussion with political Islamists is to try and make sure that they and their supporters stay in the non-violent space, that we find a place for them within constitutional democratic politics. And the challenge I throw down to them is, I am a liberal with a small l, secular, gay politician. Why are you, as political Islamists, then not an existential threat to me? And the challenge to them is to find, is in a sense then to find a route around, through the global human rights and the Universal Declaration of Human Rights, to identify what should be in the public and the private space as to what they intend to legislate for, and how will they then protect my freedoms as being secular in a state that they would want to make Islamic. How would they, even if they publicly disapproved of my sexuality, it is innate, and there is therefore I deserve private protection because of something of which is not a choice. It is part of who I am, and as a liberal in a society which might then get governed by a majority political view, if you're political Islam, which is anything but liberal, how are you going to protect the rights of political opposition and enable then there to be a proper continuing democratic debate in those countries. And so I just throw that out as an example of the work that I'm engaged in with two things that might not seem completely compatible, but I think they absolutely are, and they go right to the heart of the discussion that we're going to have today. But it's now my pleasure to introduce our first speaker, who is Jonathan Cooper, who is the Chief Executive of the Human Dignity Trust. It's been my pleasure to work with Jonathan for the last couple of years as I've begun to get engaged in this area. You will see from Jonathan's biography that's in front of you that he's a very distinguished human rights lawyer, and now is working through the Human Dignity Trust then to avail that legal skill and practice to people in parts of the world who are in the most desperate need of it, to then have proper legal representation where life is, and the legal challenges they face are particularly difficult, certainly by any standard applied through the United Kingdom. Jonathan, over to you.
Thank you very much, Crispin, and ladies and gentlemen. It's a pleasure to have the opportunity to spend the next 15 minutes with you just looking at this question of sexual orientation and gender identity and the issues that it raises. And it's very interesting to reflect on the Magna Carta, and that 800 years ago there was that notion that government should be accountable. But really the Magna Carta is also about arbitrary government. It's about, what King John was doing was he created a government regime that was totally arbitrary and therefore unaccountable. And what we have seen over the next 800 years is ever-increasing opportunities and need to make government more accountable. And this issue that I'm going to spend 15 minutes looking at is a sort of classic issue about what is the role of the state in the context of using criminal laws, and I'm only going to talk about the criminalization of homosexuality. I'm not here to talk about non-discrimination against gay and lesbian people, and I'm certainly not here to talk about equal marriage. I don't consider those to be human rights issues. I think that they may be issues that are good practice and good policy, but I don't think they engage the core human rights that I'm about to look at now. And so when we look at no, I'm doing that wrong. Oh, can somebody help me? When we look at the issue of sexual orientation, over 79 jurisdictions across the globe continue to criminalize homosexuality. And when they are criminalizing homosexuality, they are they are criminalizing intimacy between adults of the same sex who wish to engage in intimacy with that other adult. And so we're not talking about sexually abusive relationships, we're not talking about coercive relationships, we are talking about laws that criminalize consenting adults who wish to engage in consensual intimacy with other adults. And another way of looking at human rights is, of course, to call them human needs. And we all know that we all have that need for intimacy, we all have that need for love, we all have that need to be able to engage with another human being in a fulfilled and loving, or the opportunity to engage with another human being in a fulfilled and loving relationship. And so there are 79 countries across the globe that do criminalise as a straightforward breach of international human rights law. International human rights law is clear. You cannot criminalise somebody because of their identity, whether that identity is their ethnic identity, their racial identity, or their sexual identity. It doesn't matter. You cannot criminalise identity. And I think it's important that we remember that this is real. The consequences of criminalisation are real, and there can be no such thing as benign criminalisation. You just take 1 week, the last week of January, and this is just a handful of the level of violence and persecution that the gay and lesbian community across the globe will have been experiencing. And today and next week and next month, there will be similar comparable violations of their human rights. So I've just taken 1 week, one snapshot of 1 week to look at the issues that people are exposed to as a consequence of criminalisation. When we look at this notion that there can be no such thing as a benign criminalisation, we see that with criminalisation comes all kinds of harms. Not only are there harms for individuals, there are harms for societies, there are harms for cultures. Criminalisation creates an economic burden on the state. For those of you who come from jurisdictions that do criminalise, you are adding to your problems, and certainly your economic problems, by imposing criminalisation, because with criminalisation comes significant costs, and you also aren't getting the advantages because you've so marginalised a particular community. You're not getting their kind of economic advantage by criminalising them. And so I think it is a genuine crisis for the Commonwealth. If you look at the Commonwealth, it represents 30% of the population. Of the world's population, 80% of Commonwealth countries do criminalise homosexuality, and 60% of all HIV cases across the globe come from within the Commonwealth. And so therefore it's just another example of the fact that by criminalising, you're exposing people to greater risks, a greater burden on the state, because obviously there will be healthcare issues there. And another clear evidence supporting what UNAIDS has said, that criminalisation both boosts and causes HIV infections. We know that if you are from the Commonwealth Caribbean, i.e. the English-speaking Caribbean, where every jurisdiction there criminalises but the Bahamas, you will have, if you're a gay man, you will have a 1 in 4 chance of being infected with HIV. For the rest of the Caribbean, the risk is 1 in 15. And so once again, we have clear evidence that not only is criminalisation, I would argue, morally wrong, it is also a threat to society. And addressing the issue that we're looking at today, or this session, about kind of cultural relativity, there was a case that was brought by an activist in a country. He challenged criminalisation of homosexuality through the courts. And he went to the highest court in the land, and he tried to argue that to criminalise him because he was gay was a violation of his constitutional rights and his human rights. And that court held that a right to private consensual homosexual intimacy could not be derived from the religious and democratic nature of the state. And the court found as follows, that homosexuality has always been condemned in religious texts, and it has equally been regarded by society for many centuries as an offence against nature and a very serious crime. The court also found that homosexuality, whether the condition be congenital or acquired, causes great distress and unhappiness for the individual and can lead to depression and suicide. That the homosexually orientated can be importuned into a homosexual lifestyle which will become habitual, and that homosexual conduct in other countries can create a health crisis, and that homosexual conduct is inimical to marriage per se. Can I just ask you, if you don't mind me throwing out a question at this stage, what country do you think that is, that their highest court came to that conclusion? A constitutional challenge, and this is what the court found when they basically upheld the laws criminalising homosexuality. Anybody got an idea? It's Ireland. And so when you ask yourselves, well, is homosexuality un-African? Is homosexuality un-Asian? Is homosexuality un-Caribbean? Is homosexuality un-British? Is homosexuality un-Irish? Well, clearly, the Irish Constitutional Court considered homosexuality to be un-Irish, and these were their justifications. It was the European Court of Human Rights that recognised that there must be a right to respect for private life. There must be a recognition that there's a private space whereby people can engage in intimacy in the privacy of their own homes. So looking at that question, is there a cultural relativism to homosexuality? Well, the answer probably is yes, and the answer is probably no. Everywhere in the world, there will be gay and lesbian people. There will also be trans people. As I speak now, no doubt a little baby lesbian girl is being born. The point is, to criminalise these people is a fundamental violation of human rights, and the reality is, the fact that the Commonwealth has adopted this approach comes solely from British colonial rule. It was the British hang-up of the 19th century that has led to these laws being spread across the Commonwealth. They did not exist before the British turned up. And so therefore, when you are asking yourself the question, should we be continuing to criminalise, I emphasise this last bullet point. By upholding these laws, British colonial values are being maintained. And I think that's a key point to remember. There is the unique thing about criminalisation is it comes from the British. It comes from the British, whether the British were in Egypt, whether the British were in Ireland, whether the British were in Iraq, i.e. not Commonwealth jurisdictions. When the English were in North America, they left their legacy laws there before the War of Independence and the creation of the American state as we now know it. And is the only route the choice to go down the criminalisation route? Well, we know that the only source of homophobia comes from the Bible. There is no other source. In jurisdictions that haven't come from a Bible tradition, there is no homophobia. We can't get into a theological debate here, but there is no source, no theological basis for homophobia in the Bible. And even if one can be identified, that it's a choice, therefore, to opt to be persecutory, or you could take the route of Archbishop Tutu. And it is worth reading this. All over the world, lesbian, gay, bisexual and transgender people are persecuted. They face violence, torture and criminal sanctions because of how they live and who they love. We make them doubt that they too are children of God, and this must be nearly the ultimate blasphemy. And it is interesting that instead of choosing this route, we choose, or many jurisdictions choose, the route of persecution. So, human rights law is clear, as I've already stressed. It comes ultimately from the Universal Declaration of Human Rights. As we know, the Universal Declaration of Human Rights guarantees rights to everyone. So we look at the situation in 1990, where we see the overwhelming majority of the world did persecute the gay and lesbian community by criminalising them. The overwhelming majority, but by 2015, we see it's a significantly smaller proportion of the world. And the reason why that has happened is because we have upheld human rights laws. And if we go back to that slide, do we find that all of those jurisdictions that did once criminalise, that no longer criminalise, have they sunk into an abyss of hell and dysfunction? Of course they haven't. It makes no difference. It makes no difference to the state whether you do or don't criminalise, other than to impose huge burdens upon the state. You have a country like the Cayman Islands, which is literally 20 minutes away from Jamaica. The Cayman Islands do not criminalise, Jamaica does. It makes no difference to the quality of society by criminalising, or by not criminalising in Cayman, but by criminalising in Jamaica. Yet the human cost is huge and significant. I'm going to skip through these, but these are just examples of where there have been successful legal challenges by upholding international human rights law and domestic constitutional law. And we face a new threat. Not content with existing criminal laws targeting and persecuting the gay and lesbian community, in a couple of jurisdictions we've seen laws which are enhancing the criminalisation of the gay and lesbian community. It's literally a form of apartheid. In fact, it's a worse system than apartheid because it's seeking to basically airbrush the gay and lesbian community out of existence. Now, when we're looking at these enhanced criminalisation laws that exist now in Nigeria and in Gambia, and there have been attempts to introduce them in Uganda and in other jurisdictions, I think if you are contemplating that, you are almost certainly committing a crime against humanity, and people need to be aware of that. And this US court, which was challenging the actions of a US evangelical, Scott Lively, who had been promoting these sorts of laws in Uganda, that court considered, on a preliminary hearing, the case continues, but on a preliminary hearing, that what Scott Lively had been doing was, by targeting the gay and lesbian community in this way, was, to all intents and purposes, engaging issues that touched upon crimes against humanity. So when we are talking about how do we address this issue, we shouldn't just look at this as being litigation. Of course, litigation gives a state a cover, and states, if these laws are being challenged in your jurisdiction, I urge you not to defend them in any overly zealous way. But of course, the best way to deal with this is through legislation, and that's how we should approach it, through legislation. And you should be looking at ensuring your sexual offences laws are victim-centred, that don't discriminate, and that ensure that those who are victims of sexual offences are properly protected, not just now, but also in the future. The other thing that we have is, of course, the persecution of the gay and lesbian community creates a problem across the globe in terms of asylum, and many individuals then are put in a position where they are forced to claim asylum. The question, therefore, is the asylum system up to addressing these issues around LGBT persecution? So, in our 800th anniversary of the Magna Carta, it's just worth reflecting a little bit on the gay history of the Magna Carta. King John's brother, Richard, was a gay man. I think that's indisputable. He was almost certainly in a relationship with the King of France. And so we need to remember that when we're looking at this issue of homosexuality, it's not new. It's as old as the world itself. It's nothing to fear. Trust me. If gay and lesbian people if you cease to persecute the gay and lesbian community, it will make no difference to you and your lives and your families and your society. But what it will do is make a significant difference to those that are persecuted because of the criminal laws that are designed solely to target them for engaging in the intimacy that they have no other choice but to engage in. Thank you very much.
Jonathan, thank you very much indeed. Terrifically disciplined as well. 15 minutes on the nail. And it's now my pleasure to introduce Professor Frans Viljoen. So we're going to move from the lawyer to the academic with a legal flavour. Frans Viljoen is the director of the Centre for Human Rights at the University of Pretoria. His research area is international human rights law with a focus on African regional human rights, and he's also editor-in-chief of the African Human Rights Law Journal. So I think we're really lucky to have such an expert to speak to us this morning. Frans, over to you.
Thank you very much, and it's a great honor to be with you, honorable members. And let me put my cards on the table immediately. Yes, I'm a human rights lawyer, so my talk, in a way, will also try to explore some kind of legal framework without being prescriptive, obviously, but to try to contemplate the framework of looking at the potential conflict between culture and rights. And then secondly, I'm an African, so my examples and my references to a great extent will also be back to Africa specifically. First then, it's not a surprise that I will come with the angle that human rights is enjoying primacy. When we look at culture and human rights potentially coming into conflict, it is a given that human rights is a conflict, not only because I may think and want it to be so, but I think because all the countries from which we come have constitutions with bills of rights, justiciable rights, which are anchored in constitutions that are supreme. So whatever legal framework one derives legislation from is sourced in that supremacy of the constitution with its rights framework. This is bolstered by the international treaties that all our countries have ratified, have accepted as binding. And if I look in three areas that I will kind of revert back to, that of the rights of women, we clearly in all our constitutions have the right to equality. In all our countries we have ratified, with very few exceptions, the UN Convention on the Rights of, for all forms of discrimination against women being prohibited. For children, the constitutions anchor the rights of the child, often with the best interest of the child principle being enshrined, and all our countries, in fact all the countries in the world, have ratified the UN Convention on the Rights of the Child, except the United States. And then as far as the issue of sexual orientation, gender identity is concerned, I think it should be our starting point that irrespective of such sexual minority groups not being mentioned in the constitutions perhaps that we're working on, their rights are implicitly, as human beings, guaranteed in these constitutions. And I think I have good authority to say so, because recently the African Commission on Human and People's Rights, interpreting the African Regional Human Rights Instrument, the African Charter on Human and People's Rights, adopted a resolution in which the African Commission, called on all the AU member states to refrain from engaging or allowing violence on the basis of sexual orientation to be perpetrated, and to actually ensure the effective prosecution and punishment of those engaged in acts of violence. So at the very least, we are conceding, if you like, that gays and lesbians have those basic rights to dignity, to not to be cruelly and inhumanly treated, and for bodily security and integrity. And clearly, it certainly cannot be different. So that then, I think, is the framework through which would be mediated any discussion on a clash between culture and rights. So even if rights, though, has primacy, it does not mean that rights apply absolutely. It does not mean that cultural claims are rendered irrelevant. All of us know that rights may be limited, and rights need to be balanced. So I think the main contribution that the rights framework really brings is that it informs us with this notion of a balancing exercise, that no claim to cultural override can stand by itself. It has to mediate it through the filter of human rights. And in all our systems, there's some form of a proportionality test that is applied. That on the one hand, there are these rights that are undisputably part of all our constitutional frameworks. And if those rights are to be limited, these limitations are only countenanced if they are justifiable in a rational, evidence-based exercise. And it is this culture of justification, I think, that we as South Africans also celebrate. We have moved in South Africa from a culture of authority, where the executive could, through fiat, determine, for example, what needs to be done. The legislature prescribed, there was no second-guessing the legislature. We've moved from a culture of authority to one of justification. And for me, that is the essence, that yes, claims can be made on the basis of culture, but these claims are made in a human rights framework, and the resolution of these claims have to take place through a balancing where we look at both the right at stake and the veracity, the value, the legitimacy of the cultural claim. Against this background, I think we can look at the way in which culture and human rights conflict in Africa in two broad senses. And I also got that from the session I attended this morning on forced marriage. On the one hand, many of our legislatures have in fact adopted laws compliant with human rights. But the cultural claim problem comes through the non-implementation, the disjuncture between the laws that are human rights compliant and the actual non-compliance in our countries. On the other hand, the cultural claim can come through the process of adopting new laws. For example, decriminalization, it's against our culture to decriminalize sodomy being criminalized in the country. That would be the second layer. So let me reflect a little bit on the first, namely the non-implementation due to, if you like, cultural claims. When we are faced with such a situation, I think we have many examples. We heard this morning also, for example, of the minimum age of marriage being set very firmly in many countries. We heard about Bangladesh, Cameroon, Ghana, for example, but in practice, on the basis that these are cultural practices that have persisted for a long time, these laws are not being complied with. We have the same with FGM in many of our countries. Even in respect of sexual orientation, I'd say as a South African, we have a very good protection under law, but in our actual practice, there are still great stereotype and prejudice that plays out in sometimes very violent ways against people who are of the same sex or sexual orientation. So the question is, I suppose, how do parliamentarians perhaps think about these kinds of ways of human rights being conflicting with culture? And I would suggest that one has to obviously take into account that the lived normative life worlds of one's populations have to be reflected in one's laws to the extent possible. But as one then adopts laws that obviously will steer the life worlds into a particular direction. It would be dishonest and perhaps too facile to not engage with these issues as one goes about the process of adopting laws. So I think the kind of approach I would suggest is that one would, through the democratic deliberative process, face up to the real challenges that will arise and face them square on. Include, to the extent possible, these issues in the laws themselves. In the FGM law, one should talk about the non-legal ways of dealing with this issue, which obviously would be education, sensitization, broader societal issues, socioeconomic rights issues. So one cannot leave in this facile package a law that needs to address a very deep societal issue and then be somehow surprised when there is non-implementation through cultural resistance. I think it needs to be in the law, but if it's not, clearly then through the monitoring process that parliaments should engage in, there should be some leeway also, I would suggest, to look at how can these laws now be strengthened and reinforced through linking them to the issues that will ensure their greater resonance with culture. Issues that should be engaged with as much as possible would be alternatives. So that if one looks, for example, at FGM, what is the rationale that informs FGM? It's some form of a rites of passage. And engage with communities about different ways in which the rites of passage aim could be served, and engage with communities about how these could be accomplished. Let me then move to the perhaps more problematic area of the culture being held forth, cultural tradition, as a reason not to adopt laws or as an imperative for adopting particular forms of law. I would suggest that one in this exercise needs to establish first, but what is culture? And who makes the claim, and what is this claim all about? I think culture by its very definition is an abstract notion. There is no rule book or codification of cultural values and norms in a society. It is a nebulous concept that is under contestation consistently and constantly. Therefore, any claim, I think, that is made in the name of culture is inherently suspect. It has to be treated with suspicion, if you like. And we need to ask a number of questions if those claims are made. First, who is talking? Who is making the claim based on culture, and to what end? It is often made to serve self-interest or to perpetuate particular relations of power. So one needs to interrogate what the aim and the identity behind this is. In whose name is the claim of culture specificity made? To what extent has the community whose culture is at stake here been involved in the articulation of this notion of what their culture would be meaning in this particular context? To what extent has this cultural proposition relied on the fossilization of culture? We all know that culture is dynamic, that it obviously moves and changes over time, and to trap culture and freeze it in a frame obviously means that one reduces it to something that is fossilized, and a notion like something is un-African, that we heard of before, somehow does that, in that it may freeze the idea of what culture was in an idealized setting that is based on some form of an idyllic African traditional view. Culture can also easily be homogenized, made into one singular entity, whereas culture always is hybrid and varied. In particular, in our very complex and multi-ethnic, multi-layered societies, it is almost impossible to talk about culture in the sense of a country having a culture. And this is very true also if we look at the great urban-rural divide, for example, that inform our thinking and reality in Africa today. So if one then critically looks at these claims based on culture, answering these questions, perhaps in the most of these cases, one will conclude, I believe, that what is proposed as values based on culture and long-standing tradition obviously often are linked to religious views and are most often a proxy for the views of the majority. So what the proponent really says is in the proposition is that this is the view of the moral majority. The majority has a particular view. Now, if one then has to face up and decide how to deal with the cultural claim, whether it is an authentic claim or whether it is a claim that is essentially a religious one or a one based essentially on majoritarian values, I think one may benefit from this idea of a justification, of a proportionality test, of valuing the two sides of the coin. Let me illustrate this with a reference to the issue of, for example, forced marriage. An argument that forced marriage is against culture can obviously not be determined by starting to analyze the culture and looking at the arguments, etc., etc. The easier and the more, I think, productive way to look at it would be to say, but yes, if there is early marriage, what on one hand would be the impact on the rights that are contained in the framework of this particular country. So we are localizing this debate. What are the implications for rights of women, of men, the rights to health, to autonomy, dignity? Now, any inroads into rights may only really be justifiable if there is a societal objective which this cultural practice ostensibly then purports to play. And in this process, these societal objectives should be scrutinized and should be analyzed to see if the objective is a legitimate one, and if there aren't ways that are less restrictive in which the same objective, for example, could be attained. If we apply this to the issue of criminalization of sexual conduct of people of the same sex, we may then also ask, if you decriminalize or if you have a criminal law in place, what are the implications on rights? And I think we heard a number of those implications in terms of the implications that criminalization would have on individuals who are affected. Then the question will be, what are the purposes? What societal purposes are being served by retaining this? Scrutinize these and evaluate them, hold them up to the light, and see to what extent they are convincing. In terms of a claim that is based on culture that is essentially a religiously based claim, I would venture to say that most of our states are also secular, at least to the minimal extent that none of our states are legislating a religion in terms of proposing that legislation should emulate the tenets of a particular religion. Now, it may be so, and it's quite convenient and coincidental then, that in some countries in Africa, let's say Nigeria, the criminalization of sexual orientation is favored by most religions, the most dominant religions in the country. And that may be so, but I think it is very dangerous to use this then as a principle, because it is mere coincidence that there is unanimity on a particular issue. On another issue, the two religions may certainly have very, very divergent views. And it clearly shows that the secularity of the state has to be respected. The religiosity cannot determine how legislation should take place or should be directed, and it should be the diversity of the religion that is respected. The last issue, if cultural claims are essentially majoritarian claims, I think in your program you will talk about claims based on majoritarian views. I think, again, the approach is to test a democracy also in terms of how it protects those that are most vulnerable. And we're not just talking about people of a particular sexual orientation. We're looking at people who are those who are detained, the prisoners, the non-nationals. A democracy is only a democracy if it is enabled to actually protect those that are at the fringe of society. Otherwise, it will also not be meeting the essences of that concept. But clearly, I'm just suggesting this as a framework, and the framework will lead to different results, but the results have to be considered and reflected upon in each domestic national context with the frameworks of the law and in the light of the cultures. Thank you very much.
Franz, thank you very much indeed. I regret to have to tell you that I've got to introduce you to another lawyer, but at least she has disappeared from the dark side and has joined us in the light of those of us who are elected representatives on the side of right. And Valerie Vaz is one of those sickening colleagues who is just immensely popular with all of her colleagues, who is a charming person who everyone will think is their special friend until you realise that this charm has been exercised over all of her parliamentary colleagues. So she has made a very significant impact since she got elected in 2010. She serves on the Health Select Committee, but what we're really interested in here is her perhaps drawing on some of her work as a lawyer, but particularly her work around democracy in Burma, women's rights in Iran, and I think it's on those issues that we'll look forward to hearing from Valerie Vaz.
Thank you, Crispin. You are my special friend. And I suppose I come to Parliament with a lot of goodwill because my brother, Keith, has been here for 25 years. He's celebrating his anniversary of 25 years, and some people say it's been going on for a long time, but he still retains the energy and enthusiasm. So I've got a good role model there. Andrew, thank you and your team for organising this amazing event. It's so lovely to see you all here. I know the hard work that goes into these kind of events, and to get this global perspective is absolutely wonderful. So thank you for that. I've seen your agenda and I've seen what you have to do over these last 3 days. And I think it's just amazing. And I think it's amazing you're actually sitting upright at the end of this difficult morning. But one of the things that we're both going to do later on is to actually have a look at the Magna Carta. And we have it here in Lincoln Cathedral, and nobody ever goes to see it generally. And it's just that when we celebrate anniversaries, we suddenly realise how important it is. But I'm of the view of Lord Judge. I take the view that there wasn't that much in it. There were certain things that happened that had to be written down, but actually what has happened later is much more important. And I suppose what I would like to emphasise is, and as I say to every delegation I see in the CPA, Commonwealth Parliamentary Association, we are not here to lecture you. You have your own forms of laws, you have your own framework, you have your own way of doing things. Every country has to do that. There is the element of, obviously, colonialism in the past, and we've got to remember what the history is, but we have to move forward. But what I would say is that there are some fundamental rights that cut across all that cut across race, religion, colour, gender, everything. And those, I hope, are the ones that you will take away from in this session, not feel that we have all lectured at you. I am quite lucky in the sense that I had parents who encouraged me as a woman, and here I sort of emphasise all the minorities. I'm a woman of colour, I was born in Aden, raised in Aden until we came here when I was 10. So all my major schooling has been here. And my parents came originally from Goa. I've only been back there 2 or 3 times. It's quite an interesting, my surname is of Portuguese influence, so it's quite a mixed background. So I'm kind of like in the United Nations all in one person. And added to that, I'm left-handed, so there was a time when I was a person of the devil. my mother went to the convent where I was educated. Yes, I was taught, and I'm Catholic, and I was taught by nuns, and they wanted to change me to to be right-handed. My mother thought, no, it's fine. She's fine as it is. They did that to my uncle, and I know sometimes people end up with stutters when they change hands, but he was a brilliant doctor, sadly died at the age of 28. So we are all here as a result of what our backgrounds are. And my perspective is, I suppose, that I feel very lucky to have been born at the time that I did, and to parents who thought that we were all equal. My brother and my sister and I were all encouraged to do things, to be educated, and that was the primary purpose, and to play our part. And as a result of that, a very, very comfortable childhood in Aden, where I didn't feel, I wouldn't say we were rich in the people that we had around us, and that's part of what the background of my culture was. And so I feel that it is important to give something back, which is why it's taken me 20 years to get into Parliament. And yes, being a woman of colour, taken me 20 years, even though my brother took him slightly earlier. But let me take you on that journey, because they did have a difficult time within our particular party to get selected and elected. And we had to form what we called black sections. And many people in our party didn't like that. But as a result of that, we had 4 people of colour elected in '87. And the road for women to be elected, and I remember all these discussions at the time in the Labour Party, which are now seen to be the norm here, which is why I say to people, don't be afraid to stand up and stand out, because you only have to look at what's happening. What is the tipping point? What is the tipping point in our cultures? What is the tipping point in our politics that makes us want to change things, to make sure that we're all treated equally? Recently, I was looking at Channel 4's documentary on the way women have been murdered in Honduras. They wrap them up in plastic sacks, and basically they're murdered because they are women. They had a murderer, and they interviewed him, and he said, women are easier. And that's why I think we all have to be aware of what's going on, because it is changing. We are not valuing women. We are not ensuring that women are treated equally. Now, many of you come from countries where you had women prime ministers. You've pushed that boat out. But let me compare. We've had a woman prime minister here, Margaret Thatcher, but we're still talking about the rule of primogeniture here. It was only recently, and I do hark back, my brother had a 10-minute rule bill, what's called a 10-minute rule bill. So the firstborn of the monarch had to be a man, and that's only recently changed. They've done it in Sweden. Why is that still existing now? Why did women... Would I be standing here today if women didn't die, if they didn't chain themselves to the House of Commons railings to enable me to be standing here today as a Member of Parliament, and the same as all of you? It's not about me or you telling me what is right or wrong. But as I said to you, there are fundamental human rights. It is a brilliant document, the Human Rights Declaration, born out of violence and born out of a terrible time. But people together throughout the world said, stop, we need to stop. We must stop killing each other. We must stop persecuting each other. We must make sure that whatever we do from now on is done on the basis that we are all treated equally. I've been around the world, as Crispin has said. I've been to Burma. And what is so great about the movement in Burma, and I met Aung San Suu Kyi, on equal par with Nelson Mandela, and all of us, we're all alive now. We know what happened in South Africa. We know that the majority of people weren't allowed even to vote. And when people say that to me here, I don't think I want to vote. I don't know if anyone remembered the queues outside where the majority of people weren't allowed even to cast their ballot. And the absolute queues, I keep saying, go back to the time where there were queues outside waiting to vote. And it actually moved me. It made me quite emotional. We can learn from places like India, where they've actually digitized. It's now become digital. Every single person, whether they can read or not, whether they can write, whoever they are, has a thumbprint, and it's done digitally. So you don't get the situation where you had in America, where you worried about hanging charges and whether you got the right result. And that's the way we need to go. We need to learn from each other. There are many, many countries that are doing it right. And there are many countries that, and hopefully, Andrew, you will get a follow-up from this, so we can come back and people can see how we've moved on. Because at the end of the day, there is only one planet, and we all have to make our mark on that planet and make sure it survives for the next generation and the generation after that. 20 years ago, I'm sure I wouldn't have seen women MPs. There certainly wouldn't have been the number of women MPs in our parliament. But it takes pushing. It takes one person raising their voice, whether it's a Rosa Parks, whether it's Gandhi, whether it's Martin Luther King. It takes maybe one person that brings everybody else along. It takes one person to say, no, it's not right. We shouldn't be mutilating our young girls. It's not right. Cousins shouldn't be marrying because of what happens to the children at the end of that. It's not right that someone who loves someone else, irrespective of who they are, what gender they are, can't have the same rights as everyone else. It will take a lot, and it takes a lot of education and a lot of understanding, but we have to get there, because what we've got now is we've got a world that's being divided on the basis of religion, on the basis of people who are different. We cannot emphasise our differences. We're having our own problems with Scotland, but the thing is we are the same in the end. So one thought I would leave you is a quote from Shakespeare, which my mother always used to quote to us when we talk about equality and equality of rights and human rights. If you cut us, do we not bleed? We are all the same under the skin. Thank you very much.
Ladies and gentlemen, well, we've been treated to three rather distinct contributions, first from the campaigning lawyer, then from the academic, and Valerie, you told me you were going to give them emotion, and you certainly did. Thank you all very much for your contributions.